All right, cool.
Okay, we're live.
We are live, and I'll send the live stream around and get people. We'll get started once there's more people on the stream. But I'm really excited about today. Nicole, last time I saw you was in Florida, right?
That's
We were on
right.
the same panel
That's right.
talking
Right.
school choice stuff. Yeah, in Fort Lauderdale. And Matthew, you were at that conference too.
Yeah. In fact, I saw Nicole. You were that panel where you were both on it talking about. And I think you had a couple other folks up there, right? You had Michael Petrilli and Robert Enlow, I think, were on that same panel.
Yep. And Pat Wolf was moderating.
Yeah.
And so Matt Nielsen texted me a few weeks ago and was like, "Hey, did you see this case coming out of Oklahoma with religious charter schools? There are some people that are for and against it who I thought were on my team, but maybe aren't." So I said, we have the perfect person who we can contact to talk about the case coming out of Oklahoma. And Matt, do we have enough people to kind of get going?
Yeah, let's go for it.
Okay, cool. And well, one second. Let me actually pull up the video like I had last time so that I can quote tweet some things as we're going through this. But yeah, so I'd like to introduce everybody to our guest today. This is the Educational Freedom Institute podcast. The host, as usual, it's me, Corey DeAngelis, and my buddy Matt Nielsen. He's the co-founder of the Educational Freedom Institute, and this is the Educational Freedom Institute podcast. We also have on the show, I'm very excited about this topic and also this guest today because there's actually something that popped up today we're going to mention as well at the beginning of the show. But Nicole Garnett, she's a professor at Notre Dame School of Law. And she's an expert in all things law related to education freedom, especially when it comes to religious matters. And we were originally inviting her onto the show to talk about the case out of Oklahoma involving religious charter schools, which for a long time, I don't think we've really had religious charter schools. Oklahoma tried to make it happen. And now we've gotten all the way up to the Supreme Court. I believe they're hearing it this month. But right before today, I think, this morning, I realized that there's this other court case before the Supreme Court today out of Maryland. And Nicole's going to talk a little bit about that at a high level as well. So everybody welcome Nicole Garnett. Nicole, thanks so much for joining us on the Educational Freedom Institute podcast.
Oh, thanks so much for having me. Excited to be here.
Yeah, it's good to see you on Zoom or StreamYard. Hopefully I'll see it again. If you go to that conference, I believe it's going to be in Rome next year. So
yeah, that's what I hear.
That'll be a great time. We'll all have to make our way to that one. So tell us a little bit about this case out of Maryland today. I believe it has something to do with parents disagreeing with the books in their public schools.
Right. So this case is called Mahmoud versus Taylor, and it's a case about parental rights in the Montgomery County, Maryland public schools. So the plaintiffs are a religiously diverse group of parents who have kids in Montgomery County public schools who objected to a series of pride storybooks that were taught beginning very, very young, or mandatory reading in the Montgomery public schools. Originally, the schools were allowing parents to have religious opt-outs if they objected to the storybooks, but then they said, no, they're too important, so no more opt-outs. You can't, your kids must be exposed to this, so we want this part of our curriculum, so you have to read the books and listen to the books if you're not old enough to read. I haven't followed the case in great detail, and as a lawyer, I have to just full disclosure, I listened to about 10 minutes of the argument today because I was running around teaching and doing everything else. So I understand it was a very hot bench. So the Becket Fund for Religious Liberty challenged the this policy that said parents not only could not opt their kids out of these this sort of LGBT curriculum, but they weren't even being told that the books were being taught. They had a whole bunch of claims in the case. But the Supreme Court only agreed to hear one. So the lower court, the Fourth Circuit Court of Appeals, held that the parents did not, it wasn't a burden on your religion to not have a religious opt-out in a public school, because there's sort of a series of reasons. One is the kids really weren't being forced to believe it. They were just being exposed to it. One is, well, your opt-out is you can leave, you can go to a public school, or you can go to a private school. Maryland, as you know, Corey, only has a very modest means tested voucher, so it's probably not an option for most of these parents to just walk. So it goes to the Supreme Court. The Supreme Court has agreed to hear one question and one question only, and that is the question of whether you can assert that a public school policy or the failure to allow you to opt out of a curriculum that you find religiously objectionable, whether that is ever a religious burden. Not whether it was here, just ever a religious burden. And because the Fourth Circuit Court of Appeals said it wasn't. The rest of the claims in the case, there were many, like this was a violation of parental rights. Those are not before the court. There's just this one question about whether it was a religious burden or not. So as far as what I understand from talking to people about the argument and also just reading the commentary, there were a lot of questions that were asked. It was a hot bench. I think that although the facts of the case seem pretty outrageous to me, and I think that not being able to opt your children out is a religious burden, it really is a challenge for the courts to get their head around the problem, because here they asked, well, what if it was math? Or will it just destroy the public schools if everybody's opting out of different things and it's chaos in the public schools? Not something that Montgomery County ever was arguing until today, that it would be chaos. That it could be, in this case, it's clear that these objections are religious, but what if the religious objections are a little bit more, I don't know, I don't want my kid learning evolution. I don't want my kid learning math. I don't want my kid, learning English. That would be pretty extreme. So there's sort of a lot of those kinds of questions. There was a lot of questions in the case about what is a burden on your religion. Again, is it a burden to just be exposed? Justice Sotomayor, right out of the box today, said, what if the book was just in the library? Would that be a burden on your religion? So that's sort of this is just going to be a Pandora's box. The public schools will disintegrate if we start letting people opt out. The funds argument is, well, you're letting people opt out all the time. We have IEPs. We have, there are religious objections permitted to, say, sex ed curriculum. So because you're allowing people to opt out for non-religious reasons, you can't then say, it's sort of like the argument in Oklahoma. The only kind of reason that doesn't count is if it's a religious reason. So that's kind of the case is. I think it's a really important case, and I think it's tricky. I suspect the parents will win. That would be my guess, but will be very narrow. Sort of the court will say, yeah, the court was wrong below to say it could never be a burden on religion. We're not going to say whether it was a burden on religion. We're not going to say what we would apply if it were a burden on religion. It just can be a burden on religion, and we'll let the lower courts sort the rest of it out. That would be kind of my guess. At this
so
point,
do you think it'll be a 6-3 decision on this case?
I suspect it will be a 6-3 decision.
And it seems like it's not a very sweeping type of ruling, right? So if the parents win here, nothing really changes in Maryland, and those parents still gonna have to deal with. They get
thrown back into the lower courts, and they have to fight about it. Maybe the Maryland settles. So I don't see, this is not. They didn't. It's a very narrow. I mean, of all the questions that were in the case, they just took this one narrow question. From what I understand, I would have thought maybe it was going to be 7-2, but from what I understand about the argument, that there were a lot of sort of pushback, a lot of heated exchanges, even about sort of how do you define a burden? So you have an objection. You don't like it. Is that a burden? Is just being around something you object to being a burden? And then how do you weigh that against the school's interest, which is not insubstantial? I mean, the reason I'm a parental choice advocate is I believe that there is no such thing as one size fits all education. The public schools have to do a one size fits all education. And so they say reasonably, I think, well, okay, well, what if we let these kids out? Like, are you asking us to customize the curriculum for everybody? I think, if you think about this, we just take a step back from religion and you think about some of the school speech cases. I think you will see how it might work out. So students have free speech rights in public schools, but they're pretty limited, right? So you can't object to, I don't want to read that. I don't like, who's the book, the Zinn book, the AP US history book.
Howard Zinn, yeah.
Yeah, I don't like Howard Zinn. I love America. So don't make me read that book because it violates my free speech to read that book or to be taught from that book. That's in those cases, like the courts never really they've struggled to define exactly what students and faculty members' free speech rights are in public schools. So my sense is they'll have some kind of a similar compromise. Will they announce that there are religious rights in public schools, but without fully defining what they are, and they'll end up being pretty thin.
Do you think anyone was really surprised that the Fourth Circuit decided what they did, Nicole?
I was a little surprised that they said there just isn't a burden.
Right.
I mean, I think they could have said, I wasn't surprised that the parents lost. I always expected the parents to lose. The religious liberty claim here really hinges on, because you can't just have an objection to a book I don't like on religious grounds. I mean, it really hinges on the fact that they're giving exemptions for non-religious reasons. The facts are outrageous. This particular, I mean, they're teaching kindergarteners against the parents. The parents are Muslim, Jewish, Protestant, Catholic. They're teaching them that 3-year-olds that doctors guess what the baby's sex is when they're born.
Wow.
Which some Muslim parents have some objections to. So the facts here, I think I could see them saying, I thought that maybe something like, well, it's a burden, but given the school's interest in, having a single curriculum, we can't pick apart the curriculum in this manner or something like that. I think the court might have taken it anyway because of this. There is this, what's been referred to as the most favored nation status rule for religion that comes out of the COVID era cases where they were allowing bowling alleys to be 75% full, but requiring churches to only be 25% full. And the court says, look, if you're going to give an exemption, you have to treat religion at least as favorably as secular activity. So I think, what Beckett's arguing here is you're giving opt-outs for, IPs, and so you have to give the opt-out, you have to treat religion at least as well as what the federal law requires for disabled kids, or you're giving opt-outs, parents, non-religious objections to sex ed, but you're not allowing parents to have religious objections to the Pride storybooks. And that doesn't satisfy the sort of most favored nation rule. That rule really reflects this same idea as when we get to Oklahoma, that the Constitution requires the government to be neutral toward religion. And if you're favoring secular over religious objections, that's not neutral.
So if we win with this case today, and it goes back to a lower court, what do you think the remedy would be? Is the only remedy that the school says we're not going to teach this anymore, or we allow opt-outs? Or could they also have a remedy of, well, we've told you that you can go somewhere else, we're going to fund you to go somewhere else, kind of like what we do with the special needs?
That's not going to be the remedy.
Come on, Nicole.
Could be. You telling me there's a chance?
That's Philip Hamburger is great. Law of religion, administrative law scholars. The public schools are unconstitutional. I think that the remedy is,
it's the Hamburger.
The interesting thing is they were allowing the kids to opt out until not that long ago, which does somewhat undermine their argument that this was chaos. I mean, I heard early in the argument that in some of the schools, there were a couple dozen kids opting out, and they said this was just now they've decided that was too many. But the interesting thing in the argument, the part that I was able to catch at the very beginning, they said the average Montgomery County public school is 750 kids. So there's really not that many kids that were opting out. I think there was political pressure as there often is in these situations, to stop the opt-outs.
Yeah.
We allow, constitutionally, we allow, for example, there's a case that says that Jehovah's Witnesses don't have to participate in, they can leave rather than
Pledge of Allegiance or
Pledge of Allegiance.
yeah.
So yeah, I would say opting out, I think, would be in this narrow context, the question. But then, you know, the court is right, probably some of the justices were right to say, well, what about the next case? Because the next case isn't going to be about Pride storybooks with 12 kids. Maybe it's something more important. It's race discrimination, it's math, it's science, and more kids in certain situations. So, you know, are we inviting, another, you know, question that always comes up in, you know, are we opening up the floodgates to litigation? Everybody starts suing every public school. This is why we need school choice, so that parents can decide.
Because at the end of the day, that you can make a lot of different arguments about things that you disagree with on religious grounds, right? Like just the public school not having religion. Couldn't you make that argument that you're compelling my kids to go to school under compulsory education laws? You're forcing me to pay for this one size fits all system, and it can't be religious. So, and there's no such thing as a religiously neutral school or a values neutral school, at least.
Right.
Yeah, I think there is no such thing as a neutral education. I mean, Ashley Berner makes this argument whenever we choose. Back to Howard Zinn. I mean, when I teach education law, I put up 5 AP US history books in the speech day, and I say, which book would you pick? I mean, occasionally I'll say, I have a teacher who's actually taught AP US history, and he'd say, oh, I picked that book because I had a lot of immigrants, and I thought that was the best book because it was like geared toward, it was a good one for immigrants. I'm like, well, that's not a values neutral education. I'm not saying it's a bad value. It's just you made a value judgment.
Mm-hmm.
Now, legally, again, although there are people who have made the argument that, you know, the having secular schools is itself a violation of the Establishment Clause or something. It's establishing not religion. Those arguments aren't going to be winning arguments.
Yeah.
But I think the reality that there is no such thing as a values neutral education is the reason why we have to have choices. There's a book that I really, famous book called Exit, Voice, and Loyalty by A.O. Hirschman. And he talks about different ways, it's about companies, not schools, but different ways that people influence their companies. And one is exit, you leave; voice, you yell; and loyalty, you stay and try to change it. And I think in our American education system, we need all of those things.
Mm-hmm.
That's why we need choice. So people sometimes can exit and find their own perfect education for their kids. That's what we see is happening in places with parental choice in education. At the conference we were both at, Corey, I was talking to Doug Tuthill from Step Up for Students about what's going on in Florida with the big ESA. And he was saying, oh yeah, you know, like people are leaving the public schools because they're mad at Ron DeSantis and starting DEI learning pods and like micro schools for LGBT kids. And that's good. I mean, that's
if
great.
we disagree, that's fine. Just don't force my kid into your ideology. I won't force mine on yours.
So
right.
Yeah. So it's an interesting case to watch.
Yeah, I have one last question on this, and then maybe we can move on. But the compulsion is the issue, right? Because if states are required to provide a free and appropriate public education, FAPE, right? But that's
the IDEA requirement. That only applies to children who have special needs. Just to clarify, that's the federal requirement.
I thought that every student is required.
So every state
is it only an IDEA?
Every state constitution requires the states to provide to establish a system of public schools. The scope of that obligation and what courts have and how they've interpreted it varies from state to state. But the free and appropriate public education requirement is from the Individuals with Disabilities Education Act and only applies.
Okay.
Sometimes they say adequate. Sometimes it's, you know.
Yeah. It can be adequate. Some say high quality. Language. Some say efficient.
Yeah.
Some just say a system.
Uniform so the terminology FAPE is specific to IDEA, but the concept that every child is going to be given a publicly funded education, that's universal. Is that fair to say?
so yeah, every state requires this a system of public schools. I mean, it's interesting. I'm writing a paper about this, about parental rights and these state education mandates. Most of them were adopted around the time that Blaine amendments were adopted, and some of them were adopted in the post-Civil War period. States were required to establish public schools and constitutionalize them.
Okay.
So tell us about if you, after your question, I want her to tell the listeners about the Blaine amendments and how those came about too.
Okay. Yeah. So my question related to this is, if you're going to require that every every state, so every state has to provide some system of public education, and then you also compel them to attend a school, but you don't provide any choice outside of the district schools, then this is where it seems like you said earlier, you feel like the parents in the case that's being heard today have a pretty good shot at a win, a 6-3 decision. This is probably why, right? I mean, if they had universal school choice and every child got backpack funding and wherever they go, they get money, then there's not really an issue here. The issue is you only have this one road to travel in order to get, from home to school, that you only have one choice. There's one road to get there. But if you had universal school choice, there's not much of an argument there. Do you agree with that?
I was talking to a colleague about this. Yeah. So the compulsory school education, combined with the rule that you don't have any religious liberty rights in public schools, would not be a good system, right? I think one of the reasons that we want parents and students to have religious liberty rights in public schools, even if limited, is because they're compelled to go to school.
Yeah.
Now, obviously, in the Fourth Circuit seem to say, well, yeah, but you don't have to go to public school. You can get homeschooled. You can, I do think the case, the case that your religious liberty rights are infringed by things that you object to in public schools is weaker if you have true opt-out rights. So if you're in Texas as of next week or something,
right.
$10,000 a kid, or in Florida or Indiana, we have virtually universal vouchers, and in Florida, universal ESAs. Now, I don't think as a matter of federal constitutional law, the court would go down that road, just because you wouldn't want the shape of what a right to depend on state policy differences. That's just not the way the Supreme Court thinks about these things. So, but I do think it does highlight, if you say you really can't leave because you can't afford to leave, or it's going to cost you $25,000 to go to private school in Maryland or to homeschool. And that, at the beginning of the argument, the Becket Fund lawyer said that, like, one family had to spend $25,000 to homeschool their child. Another had to move in with grandma in order so they could afford private school for their children. That is one of the reasons why I think it would be unjust to say that parents have no religious liberty rights at all in public schools, even though we have to recognize that they're going to be limited by definition, because the schools, it really can't be cafeteria curriculum. I mean, more and more, I guess it could be more like that, but it's still, you have to pick a book. Pick the U.S. history book, and it might be offensive to somebody. So do you let them leave for the 10 minutes that they're offended and they come back in? And how does that disrupt it? I always tell my students in education law, I love teaching former teachers, and every classroom is a courtroom. It's just, there are so many decisions that my son, Tommy, who's just graduated, he's a Catholic school teacher in Detroit. Like, you have to make a million decisions that somebody might not like in a day. And you can't litigate them all.
Right.
Okay, so tell us the history of the Blaine amendments, because we deal with those in a lot of states when trying to pass school choice programs.
Well, so just to start at the end of the story, is the good news is they're not enforceable in most states anymore, because the Supreme Court has said that the states can't single out religious institutions for disfavor, even if the state constitution requires it. So Blaine amendments are state anti-establishment provisions that specifically address education. They arose in the 19th century in response to anti-Catholicism, and specifically the Catholics' objection to what was a pervasively Protestant ethos in the public schools, and decisions after seeking, again, accommodations. There's really interesting, like the St. Isidore case we'll talk about in a minute, Catholic school, but also Mahmoud it's not a new issue. Like the Catholics, before they started their own schools in the 19th century, the first thing they did was ask to be exempted from curricular practices that they objected to on religious grounds, and specifically the recitation, typically of the King James Bible. They would ask to be able to recite from the Dewey Rum's Bible, the Catholic Bible, and they were always told no. Sometimes they would ask to just not have to recite from the Bible. Courts said things like that is just absurd. Those are absurd claims. So we're talking in 2025 about
the same problem.
The same problem that was being litigated in 1855 in Pennsylvania. And so Catholics eventually say, forget it. If you're not going to accommodate us, we're leaving. We're going to build our own school system. And they argued on quality grounds that they should get money for their schools, because they said, well, your schools are Protestant. This public schools, the common schools as they were then known, are Protestant. We're going to educate kids, and our schools will be Catholic. So, it's all is fair. Give us some money. And as early as 1842, the first Archbishop of New York City was demanding public funding for Catholic schools on equality grounds. His name was John Hughes. He's one of my heroes. They called him Dagger John.
It's a cool nickname.
He liked it. He was a firebrand of a guy. But anyway, he lost, and there was backlash. So the backlash was to a concern that the Catholics were seeking to infiltrate the public schools by demanding accommodations, and then they're going to set up their shadow school system. A lot of anti-Catholicism. So the backlash against the demands for public funding were states adopting provisions in their own constitutions banning the funding of sectarian education. In the post-Civil War period, a man named James Blaine, that's why they're called Blaine Amendments, attempted to amend the federal constitution to prohibit public funding of sectarian schools. This fell just a few votes short of passing in Congress. And after that, Congress required states to adopt something they're called Baby Blaine Amendments in their state constitutions. And you're right, Corey, these have haunted the school choice movement forever, because the argument, even after we win in Zelman in 2002, the court says it's okay to have parental choice. It doesn't violate the federal constitution. Everybody said, well, there are these state Blaine amendments. They prohibit it. And it's really not until the last 5 years or so where the Supreme Court has said pretty clearly, look, we have this thing called the supremacy clause in the Constitution, which means the federal Constitution trumps the state law. And so if your Constitution requires religious discrimination, those provisions just aren't enforceable.
Boom.
So state legislators do not know that. A lot of times they'll still say, but we have a Blaine Amendment. I've testified in state legislation. I'm like, I know you have a Blaine Amendment, but it doesn't matter. It's not enforceable. But we have a Blaine Amendment. But what about our Blaine Amendment? Sometimes
everywhere.
Oklahoma Supreme Court seems to think theirs is still enforceable, although they insist it's not a Blaine Amendment. So I think we have a lot of educating to do in education policy, and
we still
thinking.
And this is why we lost in South Carolina, right? Or was this not a Blaine?
Yeah, this really is in the weeds, but there are a very few Blaine amendments that prohibit the funding of any private school, and since they would arguably prohibit, they don't treat religion differently than non-religion. They are not subject to the non-discrimination requirement.
But you can make the argument that back at the time when the Blaine Amendment was created, private basically meant Catholic school, right? And you could
and they all say, usually it says private or sectarian, or private and sectarian. Yeah. So I think there's an argument to be made that they're doing the same work. It's just that since the free exercise rule is do not discriminate against religious schools, if you're saying no private schools, it's harder to make a federal constitutional claim. I mean, the South Carolina Blaine Amendment, that case complicated because it was re-ratified in the 1970s. But the original Blaine Amendment was racist and anti-Catholic, because one of the reasons they adopted in the post-Reconstruction Constitution, the segregation Constitution, was because religious missionaries were coming from the North and educating freed slaves. And the Sermonists didn't like that because they had a literacy test for voting. So they thought they could use their Blaine Amendment to keep Black people from voting and get rid of the missionaries. The history is pretty clear on that. It's just that it's a complicated historical story because state constitutions get re-amended, and it was changed in the 70s. So arguably that history is no longer relevant. I think it is, but we can find
thankfully in South Carolina, the Chief Justice was the primary dissent.
Are they going to be able to fix it?
Well, they passed another program, I think, or they're about to. And so we have a new court, and I think we might be able to flip it one vote the other way, and we might win this time. So would you say that's why we have so many Catholic schools today is because of this history? That's, I don't know what the percentage is, but it seems like half of the private schools are Catholic schools.
Well, unfortunately declining, but yeah, for sure. I mean, so in the 1850s, in a series of bishops' councils, the church basically made a decision that every parish should have a school. It's actually not like that in other countries. So most of our K-8 schools are parochial schools, so they're run by a church. So my son, I have 4 kids, only one left at home, but he's in, same. They've all gone to the same Catholic school that was founded by the same guy who founded Notre Dame, actually in the 1850s. A same priest, and so it's run by the church, and so we had basically until the post-Vatican Council a school at every church, and that is a pretty big footprint. And it was a reaction to this idea that originally the public school system was not serving our children well. I think later on it becomes more than that. It's sort of the catechism teaches that that parents have a duty to educate their children in the faith, and that the Catholic schools were the best mechanism by which to do that. Now that it has changed, the doctrine has changed, the interpretation of that rule has changed, and we've had a lot of school closures. But one of the reasons I think so many Catholic schools have closed in the urban areas in particular, one is obviously no vouchers, but another is there were just too many of them. You might have like 5 in 1 square mile. I mean, because there would be the Polish school, the Irish school, the Italian school, the Hungarian school. Every parish had a school. Some of them were ethnic parishes.
Okay, so we've gone over half an hour, so we better transition. We could talk about this stuff all day to the real reason we brought you on, Nicole, to talk about something that you wrote about in the Wall Street Journal. Actually, I recommend everybody go check it out, in a piece with the headline of "Religious Schools Are Okay in Oklahoma." So Oklahoma, what's going on there? Why is this being taken to the Supreme Court? I think it has something to do with religious charter schools. So take it away.
So it's a long story. I'll try to tell the beginning, middle, and the end in a very short fashion, but most of the listeners will know that what charter schools are, which is unusual because most people don't. But 46 states have a charter school law. These, you might think of them as sort of like a request for proposal. So the idea of the charter schools, which interestingly, you probably know this, but the first charter school law and the first modern voucher law were enacted within 6 months of each other in neighboring states. In 1990 and 1991. In 1991, Minnesota enacts the first charter school law. And the charter school laws basically are, they're called public schools, and that's the crux of the argument in the Supreme Court. But the programs say, we want diversity, we want more educational opportunity, so we invite, in most states, nonprofits, and a few states, for-profit entities to make proposals to operate diverse schools. So and you get to set your curriculum. You get to pick your priorities, your themes. You might have you know, in Oklahoma, for example, there are art schools, there are Montessori schools, charter schools, there are STEM charter schools. There's even a Comanche charter school, which is odd because Comanche aren't really one of the tribes that one associates with Oklahoma, but my husband's in the Choctaw, so he was like Comanche. So there's a Native American school. And the idea is like, we are going to free you from, we're going to be privately operated. You're not controlled like public schools by the government. And we're going to free you from these regulations in order to foster pluralism and educational diversity and opportunity. But all 46 states with charter school laws prohibit one kind of pluralism, and that is religious pluralism. So most states all states require charter schools to be quote unquote non-sectarian schools, and most states prohibit them from even being affiliated with a religious organization. Oklahoma has both of those restrictions. In a series of recent cases, culminating in this case called Carson versus Macon in 2022, the Supreme Court just set down a very clear standard, and it's something like this in the education context. A state need not subsidize private education, but once it chooses to do so, it may not refuse to subsidize religious education. That rule extends beyond education. It applies to every time the government enters into, establishes a program that enlists the private entities to advance public goals like education, healthcare, social services, you know, poverty alleviation. The rule says if you're going to do that, you don't have to do it. But once you subsidize a private entity, you can't discriminate against religious organizations, and you can't refuse to fund religious conduct. That's the rule. Okay, so that's the.
And that was from the Montana case with the.
That's the Montana case.
John Roberts.
The Montana case was called Espinoza versus Montana. Supreme Court invalidates a modest tax credit scholarship program because the program, Supreme Court of Montana, because the program included religious schools. The Supreme Court says that's religious discrimination. You can't do it. You don't have to have a program, but if you have a program, you can't say we're going to not have you're not going to discriminate against religious schools. Interestingly, in Espinoza versus Montana, Justice Breyer asks, he's in his dissent, what about charter schools? Now, if you know what a charter school is, I would commend his dissent to you because he had no idea what they were. It was sort of a word salad, but it was like, what about charter schools? And obviously, this is the next question. So the question is a charter school public or private? It's called public, but it's not like the public schools that I went to in suburban Kansas City in the Blue Valley Unified School District, because the schools aren't governmental. They're not run by the government, and they are privately operated. There's a contract with the state, so they have to be tuition free. They get public funds, and they're called public. So the St. Isidore's, so that's the background. The St. Isidore of Sevilla Catholic Virtual School is a joint project of the two Catholic dioceses in Oklahoma. Oklahoma is a large rural state with many underserved communities, and during COVID, when they had to go remote, this diocese started saying like, wow, maybe we should keep doing this. Like we're not bad at it. And we could give the gift of Catholic education to kids who might live 200 or 300 miles from the closest bricks and mortar school. But how will we pay for this? It just happened that I also happened to be writing about this at the same time. And so someone said, somebody in Oklahoma wants to talk to you about your paper. This never happens if you're a law professor, by the way. No one reads anything that you write.
Yeah.
There's no report for the Manhattan Institute, and now there's a Supreme Court case. So Notre Dame was just founding a religious liberty clinic at the time, so I was able to talk to the good folks in Oklahoma and about this, and we said, look, Oklahoma says you can't be religious. That might be unconstitutional. It might be religious discrimination. We have a religious liberty clinic. This sounds like a cool project for the religious liberty clinic. As student-driven organizations, we teach kids how to be lawyers in the clinics. That's what legal clinics do. Maybe we'll have them write you a memo or something. So things unfolded in ways that we couldn't have expected. Soonish after we started talking to Oklahoma, the Attorney General of Oklahoma, then Attorney General John O'Connor, issued an opinion letter saying that the laws banning religious charter schools violated the Free Exercise Clause. That opened the door for St. Isidore to apply for a charter. He was primaried His
Yep.
predecessor changed his mind and revoked the letter.
Hmm.
By that time, the school had already applied. The charter school board in Oklahoma said in its deliberations, this is a really great application. The only reason we wouldn't approve you is because you are religious, and we can't do that. So you get your
Whoa.
So the school is approved. The new Attorney General of Oklahoma, his name is Mr. Drummond, Gettner Drummond, sues the charter school board. One really weird thing about this case at the Supreme Court is it's really Oklahoma versus Oklahoma because the states on both sides of the case. The charter school board agrees the school should be approved, and the Attorney General says it shouldn't. So goes to Oklahoma Supreme Court. The Oklahoma Supreme Court agrees with Mr. Drummond. He says, this violates the Oklahoma Constitution. Also violates the Establishment Clause because it's a state actor. It's not a private actor. So it orders the charter board to revoke the contract. And the school and the state filed cert petitions. And I feel lots of people surprised the court agreed to hear it. It will be, arguments are next Wednesday, the last argument of the term.
So a week from tomorrow.
A week from tomorrow.
Okay.
And so the Oklahoma Charter School Board at the state level rejected their
they approved
application. They approved it, and then so when did it?
So the charter school board approved the application, saying we are not going to enforce the provisions that require you to be secular because those provisions are unconstitutional. Then the Attorney General sued the charter school board in Oklahoma Supreme Court. Oklahoma Supreme Court agrees with the Attorney General and says to the charter school board, what you did was unconstitutionally illegal under Oklahoma law and unconstitutional under the Federal Establishment Clause, and ordered the charter school board to revoke the charter. So the contract has been revoked, and now in the Supreme Court, the Oklahoma Charter School Board is arguing that the Free Exercise Clause requires Oklahoma to approve the school. The school is arguing that the Free Exercise Clause requires the state to approve the charter, and the Solicitor General of the United States, Trump administration, is arguing that same. So there'll be three people arguing on that side against not Mr. Drummond. They hired a different lawyer, a former Solicitor General. So it will be 4 arguments. It may take all day. I don't know. I'm excited. But so the real case, the question in the case, and I'm happy to talk about sort of the policy implications and maybe some pushback from the folks in the charter school world and the even the parental choice world, I guess. The real question, everybody agrees in the case, is whether a charter school in Oklahoma under these circumstances is a private actor or a government actor.
Right.
If it's a private actor, it's protected by the Free Exercise Clause, and it can't be required to be secular. If it's a government actor, it's bound by the Establishment Clause, and it arguably must be secular.
So you can be something that's labeled public, but still non-government.
So the Supreme Court has made clear that state law labels don't control constitutional questions, and has also held that the label public does not make you governmental. There was a case in the 70s about public utilities where the argument was, they're governmental because they're public.
Point. That's a great
most
point.
government contractors and so the other thing the Supreme Court has made clear is just because you are regulated by the government doesn't turn you into the government. Just because you get government money doesn't turn you into the government. Government contractors, Lockheed Martin is not the United States, and probably it has one customer, maybe like 2. And the label public doesn't turn you into the government. But really, the question comes down to how closely the school is controlled by the state. And I don't think it's controlled very closely by the state. There are strings that come with being a charter. The charter can be revoked, so.
Yeah, but you can make that argument about private schools too, right?
What?
Right. You can make the same kind of argument that the other side is trying to make about charter schools. You can apply that to private schools too, right? Private schools have certain laws that they have to adhere to. Doesn't mean that they're government schools.
Right. And some of the things that the Attorney General in his new brief argues, interestingly, so the before the up until this point, the argument has been, okay, we recognize St. Isidore is private, but because its involvement is the argument has been, is it so closely connected to the government that its actions have become state actions, the state action doctrine. It's a private actor, but it's still bound by the Constitution. Very rare that happens.
Has it ever? I'm not aware of any situation. I freely admit I'm not aware of everything. So, but I'm not aware of one situation where an individual has sued a charter school for anything and somehow made the state responsible for that. For instance, like my child,
the state is responsible. The question is whether the charter school is bound by the Constitution. And there are cases about that.
So, but, and fair enough, but here's my question, because the argument, I assume that hopefully someone's making this argument. I'm sure they are. Much smarter people than me are arguing these cases. But when a state government gives public taxpayer dollars to a private entity, which charter schools are, right? In any case, either they're nonprofit or for-profit, doesn't matter. They're individual organizations that are owned either by nonprofit by a board or by individuals or corporation or a group. The argument I assume that they would be making and have made is that once those public dollars enter into a private organization's bank account, they're no longer public dollars. They're private dollars.
Yeah, I mean, the way the lawsuits would come up is, so like extracting from this case to another recent case is, there was a case out of North Carolina called Peltier versus Charter Day School. It was a classical school that required girls to wear skirts.
Yes. Yeah, that was what, 3, 4? No, this was
North Carolina. It was 3 or 4 years ago. So the school gets sued. The school says, we're not the government and we're not bound by it. They say it was an equal protection violation. It was sex discrimination. And they say we're not a state actor. Like we're a private actor. We're privately run. We're a private board. So we're not bound by the equal protection clause. And the Fourth Circuit said it was a state actor. It wasn't really about like holding the state itself responsible for the charter school's action. It was about whether the charter school was bound by the Constitution. The same issue here, like St. Isidore.
Did that other one go to the Supreme Court?
Brief, everybody agreed that St. Isidore was private. The only question was whether it was bound by the Establishment Clause. Now, the Attorney General has said, actually, it's a government. Like a charter school is a governmental school. Right. It's created by the government.
Well, the Attorney General is just against school choice in general.
Yeah.
He was against the voucher program too.
He's an interesting guy. But yeah, so they say, well, it was created by the government, so it is the government. I just, look, I know it's like rose-colored glasses, but that can't be true. I mean, the Archbishop, the St. Isidore has 2 members of its board. I mean, like, I think 2 principal voting members, the Archbishop of Oklahoma City and the Bishop of Tulsa. They aren't Oklahoma. Like, it can't be. Like, these 2 Catholic bishops have become the state of Oklahoma. But so that's what you'll hear a lot of questions in the case about, the fight. Interestingly, a lot of folks in the public square are talking a lot about, like, will this introduce like prayer into public schools? And my answer is, this has nothing to do with that. Like the whole fight here is this a government school or is it a private school? Yep. It doesn't have anything to do with Blue Valley North High School. The Mustangs,
we know what the government-run schools are. We're just trying
to decide what this thing is.
"Quote unquote" public schools, but not government-run.
So, so that's whether this non-discrimination rule applies to this charter school is whether or not the charter school is public or private, government or private.
And so if we win here, and I think we will, this only applies to Oklahoma. So then Oklahoma would be able to start opening a bunch of Catholic charter schools if they wanted. Catholic charter schools would be able to open.
Well, so religious schools of all kinds could apply, and their applications would have to be treated equally with any secular school's application. Now, that doesn't mean they have to approve it. I mean, if it's a bad application, So, but they couldn't discriminate against it for being religious. Mr. Drummond, the Attorney General of Oklahoma, he's constantly harping about, the next thing is Muslim schools. I'm like, well, okay, good. Like, I feel freedom.
Right.
If they're being
Right.
peaceful and things that they have a good
You can't say no
application.
because you're Islamic. I mean,
Yeah.
that would be a constitutional violation. So in Oklahoma, the question isn't could they apply secular criteria? Of course they could. They just couldn't say no. I mean, what the charter school board said in this case is the only reason we would possibly say no is because you're religious, and that's unconstitutional. Now, outside of Oklahoma, the Supreme Court, it acts, and it's not talking in this case about anybody else's law, and different charter school laws are set up differently. But of course, it will say things that will perhaps suggest that Florida needs to permit religious charter schools. I don't know. I haven't studied every state's charter school law, but some states,
because the charter schools, they're all basically, they can be
but they're
privately
different levels
operated.
of control. Right. So some states, they're pretty
So
close.
like Wisconsin has like government-run charter schools and non-government run, I believe.
So the government-run charter schools are clearly can't. So I think there's a couple of misconceptions about the case. One is this is going to open the door to religion in district public schools. That's just nonsense. Doesn't have anything to do with this case. The second is there'll be thousands of charter schools overnight in 46 states. And that's also nonsense for all kinds of reasons. Because only one state is up there. Two is they still have to apply. And with more and more states with parental choice, even though it's more money to be a charter school, most religious schools would probably think, I'll just do the ESA. Right. I don't want to do that authorization hassle. Unfortunately, because I am an advocate for charter schools, I mean, charter schools are really under fire, and states aren't approving them in the numbers they used to.
Yeah.
So if they want to slow it down, then they have already. I mean, so I just don't think this is not a floodgates question.
So I have a question for you. If you're okay, Corey, switching gears a little bit, but we have friends.
Well, no, real quick before we switch gears. So like when we won in Montana with the Espinoza decision, Maine did something else and we had to go to the Supreme Court again. Is this similar in that way where, we're probably going to win in Oklahoma, and then what brings the next case? I guess if a religious charter school wanted to open in Florida and then the teachers unions or whoever sued to stop it, then it would potentially go to the Supreme Court, and then we'd have to.
I think it's a little different because unfortunately Espinoza.
That was supposed to be clear for all.
It wasn't clear though, because Espinoza said they have the status. This is about discriminating against religious character or status. And we're not saying that it's okay to discriminate to prevent money from going to religious education, but we're not saying that might not be different. So
Maine said we're not discriminating based on you being a religious school, just for doing religious things.
Yeah, right.
Exactly,
because that's such a big distinction for religious people.
Exactly.
Right.
So Carson closed that loophole. I mean, depending on what the court says here, I mean, I think hopefully it will be whatever the rule is, it'll be clear. And then the states will have to apply it to their own laws. It won't say that Florida has to authorize charter schools that are religious.
Right.
The state attorney general will have to make that determination. Now, and also, I guess there could be other state constitutional provisions, not Blaine amendments, that might work differently. But the rule, whatever it is, assuming that St. Isidore is victorious, under circumstances like Oklahoma, states won't be able to prohibit religious charter schools. But we don't know what that is. I don't think it's exactly the same as Carson, because they love to live open loopholes, but I can imagine, I just think that it's not quite the same, because there they just intentionally said, we're waiting to decide this thing for another day.
Okay, we've got just about 6 minutes left, and I want to squeeze in my question about some of our friends. All of us have friends who are pro school choice. They love charter schools, and they're working day in and day out to grow charter schools across the country.
Unless they're religious.
Unless they're religious charter schools. So that's the question. we've even seen some, what's the word for it? It's a Latin legal term, Nicole, and it's not amicus, it's curiae.
Amicus curiae. Yeah, friends of the court.
Okay, but there's
Sent in letters on the other side of us.
No, they wrote briefs. So I mean,
Yeah.
it is important to keep in mind that the charter schools are divided.
Yeah.
So of the briefs that the St. Isidore group and the Oklahoma Charter School Board, there were a number of charter school groups that filed briefs saying, we do not want to be the government. Please, we need our freedom. The National Alliance for Public Charter Schools filed a brief in favor of the other side.
Of being
Right.
the government. We are government schools.
Yeah, like I don't know why you would want to be the government. I mean, so I think so. Their arguments, as I understand them, they're not really legal. They're just sort of, I don't know. If you do this, then bad things.
It's more of a political, a
Right.
political argument.
So charter schools if you do this, then New Jersey will just stop authorizing charter schools altogether. Maybe they'll shut down all of us, and then millions of children will die or suffer. But I think,
Yeah, I've heard that.
so the problem with that argument, besides I think it's overblown, is that the fact that some state might discriminate against religion or not like religion. There's some state officials have antipathy to religion is the reason we prohibit religious discrimination. It's not a reason to make it so that it's the law. So that's a hard argument for me. There's another argument that folks.
That's like saying, if the Supreme Court says that schools can't discriminate based on race, well, then the schools won't serve anybody, so we shouldn't fight it at all, right?
Well, that did happen after Brown.
So similar.
Yeah.
Similar arguments.
Right. So Virginia shut its public schools down. That was a reason not to have Brown. I mean, that wouldn't have been a very good argument. I do think one other thing I will say is, there are arguments, and there are people in the private school choice world, and that's really my world. I've been in the private school choice world my whole career since the mid 90s. That say, look, this is a really bad mechanism for religious schools. It's too much government involvement in them. They would be much better off and much freer in an ESA program or a voucher program. This is actually a threat to religious liberty. Religious schools should not go there. I mean, I associate this with Darrell Bradford, a good friend of mine, would say this.
Yeah.
I think,
but you could do both, right?
So both, and so that's again not a legal argument. That's a prudential argument, and there's no reason why religious organizations partner with the government all the time, and we allow them to do so, even though by doing so sometimes they get some level of government control. We wouldn't say don't get public money for your soup kitchen because you might get regulated.
Religiously affiliated hospitals get taxpayer funding.
We have to
Medicaid
with the price of liberty, and we have to be vigilant, and we have to make decisions. And the archdioceses and the diocese in Tulsa have decided that they're going to have their autonomy and religious liberty respected, and that's their decision. The last thing I would say, because I know we're out of time, is just everybody here should remember, as much as I'm a huge fan of ESAs and vouchers, is these are not magical regulatory invincibility shields. Regulations can come when you take public money, any form of public money, not just charter schools, but also private school choice. And regulation can come if you don't.
That's right.
Yep.
And
like we're seeing in Illinois, where they're trying to come after the homeschoolers.
Right. Going after the homeschoolers.
And in Arizona right now, where we have them, where we have ESAs, they're trying to regulate them, and there's a big hearing on Monday. We'll see how that goes with the ESA handbook proposed changes. And like you said, in Illinois, where they don't have a lot of school choice, and they're regulating everybody that
tries. They're making homeschool parents register with their local school district and submit their school curriculum, and the school district is.
And if you don't, 30 days in jail for you.
Unbelievable. It's a great point. You're going to get regulated if the regulators want to regulate. And so the price of any of this is vigilance, right? Yeah.
Yep.
Yeah.
Okay. So I think we've hit about an hour. We have a lot of people watching. Is there anything else that we missed, Nicole, that you'd like to go over Some of you wish I should have asked you, but I didn't ask you.
I think we had a lot. We got whenever. There's a lot. An exciting time to be in the parental choice movement, and everybody should pray for Saint Isidore.
Yep.
And if you're Catholic, pray to Saint Isidore.
There you go.
And so you said this. You said this case is next Thursday. What's the timeline after that? Next Wednesday. Okay. I tweeted that out.
Yeah, we expect there'll be I expect an opinion on the last day of opinions, which will probably be the first week of July.
Okay.
There are 3 religious liberty cases in a row at the court in April.
So like 2 months.
This one, Mahmoud, and there was another one about Catholic charities in Wisconsin, which Wisconsin had said wasn't religious enough to be a religion, which is a whole nother story. But so it's going to be a lot of religious liberty cases at the end of the term. So
okay, I'm tweeting it out that it's going up next Wednesday.
So Corey gave his. Yeah, it's next Wednesday.
And then we'll have like 2 months after that to where we have to wait until we win after that. But,
and everybody can live stream the argument. I think it will be incredibly well argued, and it's live stream. You can live stream it on C-SPAN at 10 a.m.
Okay, cool.
Okay, Corey gave his prediction. We're going to ask you for yours. No, we won't place any bets, and we won't hold you to it, Nicole. But if you had to guess today, how does this one come down in the Supreme Court?
So I can't believe the Supreme Court will rule that the Archbishop of Oklahoma City is Oklahoma. It just doesn't work for me. So I think it'll be. So Justice Barrett recused herself. So my guess is it will be 5-3.
5-3. Okay. Corey, you think that's 5-3?
Yeah, I think she's right. Yep.
Yeah.
So we'll see.
Take her word
we
over
can't bet
yours
against
anyway.
each other because we have the same numbers. But yeah, hopefully we're both right. And yeah, I want to thank Nicole for joining us. Maybe we'll talk again soon on the Educational Freedom Institute podcast. Maybe after we celebrate this victory and see where it goes after the case next Wednesday. Everybody should tune in. I want to thank all the listeners for checking out this podcast. It's the Educational Freedom Institute podcast with Matt Nielsen and myself, Corey DeAngelis. I'm so happy that Nicole joined us today. She's a professor at Notre Dame Law School, and she's a big education freedom fighter, very smart person. And I feel lucky that she said yes to be on our podcast today.
Thank you both so much for having me.
Thanks, Nicole. Appreciate it.
Thank you. Have a good one.
Okay. Bye-bye.